Hey folks, good afternoon. I'm Greg McLawsen, the Affidavit of Support lawyer. I've been working on affidavit of support litigation in federal court for about the past decade. And I thought I would kind of share some thoughts today about how this litigation has changed over the course of the past 10 years. When I first got into this right out of law school, I had worked for the court for a period of time. And reason I got into this litigation was originally I wrote an article for a local bar association because the family law bar had said, what is this affidavit of support thing? We've heard about it from an immigration lawyer and nobody seems to know anything about it. And basically what I found was that nobody knew anything about this. And there were actually relatively few cases nationwide where the affidavit of support had been enforced. Awareness in the family law bar and the general civil litigation community was quite low. Over the past 10 years, that has changed somewhat. I would say that this is still an area where a lot of family law attorneys, it is not on their radar. But we have seen a significant maturation in the case law. So, 10 years ago, we had a handful of cases, and that's changed significantly. There are now over 156 federal court decisions on the affidavit of support. Many of those are unpublished, but still we have a lot of data out there about how federal judges treat these cases. The number one thing that we see over the past decade is a real narrowing of what these lawsuits are about. The tension that we see play out again and again in these cases is that beneficiaries, the green card holder, they want to make the case as narrow as possible. So in my worldview, the case is about, was the person sponsored through an affidavit of support? Yes, we have that easy factual question to decide. Did the person get their green card? Yes, they did. The only remaining factual question that's germane to the case is, what was the person's income? Because that determines what damages they're entitled to under the affidavit of support. And that's it. Those are the three factual issues that determine what's at issue in the lawsuit. Pretty narrow. What sponsors want to do again and again in these cases is make the lawsuit about everything under the sun. Usually, not always, but usually these are lawsuits by one former spouse against another former spouse. Sometimes they're still married when the affidavit of support lawsuit happens. And so the aggrieved US citizen spouse wants to make this about every dispute that possibly they can think of that came up in the marriage. So fraud is the classic thing that sponsors always want to argue. This comes up in virtually every case, that the sponsor says, she never loved me. It was all a fraud to begin with. She married me just for the purpose of the green card. Let's get into discovery about everything relating to the relationship so that I can demonstrate that this was all a big fraud. So that's the classic example of where federal courts have said, no, we're not going to get into that. When it comes to affirmative defenses that can be raised by the sponsor, federal courts say the only five defenses you can raise are the terminating events in the affidavit of support, primarily that the sponsored immigrant has 40 quarters of work history or has become a US citizen. Aside from that, says, for example, the 11th Circuit and the Belovich decision, there are no other defenses. So there's no reason to get into discovery and motion practice on the issue of fraud because it's just not a defense under the contract. And likewise, a counterclaim, so the sponsor seeking damages for this allegation of fraud, that's not going to be allowed either because federal question jurisdiction is the court's authority to hear a claim. Federal question jurisdiction is not so broad that the sponsor can just assert all of these additional claims that might be appropriate in a state court, but don't fall within the federal court's jurisdiction. So classic example there of where 10 years ago, sponsors were asserting the defense of fraud. Now that would always fail on its facts, But they were able to make cases much more complicated and much more expensive to litigate by getting into issues of fraud. Now, federal courts say, we're just not going to have that. And you just simply cannot raise that defense of fraud. Another emerging area in which cases have become significantly more narrow is the issue of how we calculate damages. Damages are what the plaintiff can recover financially in one of these lawsuits. And that again is tied to income. The responsibility of the sponsor is to maintain the sponsored immigrant at 125% of the federal poverty guideline. So the difference between income, 125% of the poverty guideline, that's what can be recovered in the lawsuit. To know what damages are then, we have to know what the person's income is. And historically, especially years ago, courts would consider rather expansively what constituted a person's income. So the classic example that I think is particularly inappropriate is a sponsored immigrant who's given a free place to stay. And the court could say, well, the imputed rental value of that home, I am going to say was your income. So if this unemployed elderly man, as the case was, is sleeping on the couch of a house that belongs to his friend, the court will say, well, let's look at the fair market rental value of that house and pretend that's his income. Now, that's a wildly incorrect outcome in my view, because the federal regulations specifically define what income is. And under those regulations, income means taxable income. So we have seen numerous times, just in the past year alone, where federal courts said, well, of course, we are bound by that income definition. It's right there in the federal regulations that have force of law when it comes to enforcing the affidavit of support. And so when we are assessing what a beneficiary's income is, it simply means their taxable income. That again makes the universe of issues in these cases much smaller, because it's a much narrower question to ask, what was this person's taxable income? Well, we just look at their W-2 and 1099 statements and we're done, rather than ask, well, what was everything of financial value that this person was receiving? You know, they got a $2 sandwich at a food bank. Are we going to count that as income? They got food stamps. Does that count as income? They had a shelter bed. What's the economic value of a shelter bed? That becomes a somewhat maddening enterprise to try to get into all of that valuation. Instead, federal courts, by focusing narrowly on the definition of income in the regulations, make the cases much simpler for everybody involved, because, again, it's relatively simple to figure out what somebody's taxable income was. So bottom line, in my assessment, is that over the past 10 years, these cases have gotten more streamlined and more focused, and the I-864 beneficiaries of the world are in a better place now than they were 10 years ago to effectively enforce their rights under the affidavit. Conversely, the sponsors of the world now should know that they are not getting out from under the affidavit of support contract unless it's been terminated through one of the 5 terminating events that's listed on the affidavit of support. Hope that's helpful. If folks have any questions about affidavit of support enforcement, feel free to jump into the comments. If you are the beneficiary of an affidavit of support, or you are a lawyer representing such an individual, feel free to jump onto our website. We offer free consultations all across the US via the ever popular Zoom platform. Hope everyone's well, and take care.